I say that this conflict is an effect of the Equality Act itself, and you can take a principled libertarian stance that says that employers, private sector employers and service providers should be able to discriminate with impunity.
And now, allow me to please welcome tonight's debate chairman. Please give a big welcome to Stan Billington.
Thank you, William. Thanks, guys, for coming. I know it's sunlit, so it's easier to be out. Doesn't feel so intense, doesn't it, being out while it's like this? I know the clocks have changed. The motion is: this House believes there should be no protected beliefs. We're going to take a vote at the start and end of the meeting for people for and against initially, and then we'll take one at the end to see whether your mind has changed. I'm going to try and count, although there's lots of you, so this might be a tiny bit awkward. But we're going to get your initial opinions now, and we'll see via vote later who's won via the swing tonight. So if you are for the motion, this House believes there should be no protected beliefs. If you're for the motion, please raise your hand. Cool. Okay. So this is our first as a club, our first debate where we've got only one speaker. So more pressure or more time to air one's views, depending on how they enjoy the occasion. We're very pleased to have them both. First, on the proposition side, we've got Dr. Anna Loutfi, who is a barrister. And also, she wrote last year, co-authored a report titled "The Equality Act Isn't Working." So passionately on this side. And as you have, hopefully everyone has a bio with them, as well as the format for the evening, two pieces of paper handed out. So you can see more information. I won't go into that now. And then on the other side, opposing the motion, we have Maya Forstater, who is a researcher and campaigner, and also won in, I think, 2021, won a court case which made it such that gender-critical views were a defended category, belief category within the Equality Act 2010 as a addition. And that should, I think, be everything. So I can get out of the way and welcome to the stage Dr. Anna Loutfi to propose the motion.
Thank you very much for attending today, and thank you, Maya, for agreeing to spar with me. So this is 10 minutes of whinging about the Equality Act, which I appreciate is not a particularly attractive task. And I will take the liberty of drawing heavily on the victory of Maya Forstater's Employment Appeal Tribunal in 2021, as it helps assist me in the points that I want to make. But that is not to detract from the victory that it was and the benefits that it has brought to numerous groups of people who have relied on the protected belief of gender-critical views. But I do want to break down how that particular case, Maya's case, has led to a perception of the Equality Act as something that fuels conflict of interest groups. So the debate in essence is often considered as one post-Forstater, as between people who hold protected gender-critical beliefs and those who oppose them, collectively under the rubric of trans or transgender rights. Against Maya Forstater, we might hear references to a protected characteristic, which, if you look at the Equality Act in the letter, is the protected characteristic of gender reassignment. What Maya Forstater did was put against that she believed that sex, which is also a protected characteristic under the Equality Act, is real, important, immutable, and not to be conflated with something called gender identity. And then to articulate that belief could be construed by Maya's opponents as tantamount to prejudice against trans people or anti-trans discrimination, hence the conflict. For Maya Forstater, advocates, particularly of women's rights, might say that it was crucial to secure a separate category under the rubric of sex for women as opposed to men without censure, i.e. to be able to say or express the fact that men cannot be legally recognised as women whenever and however they want to be. Now, because Maya Forstater won upon appeal, we now have this debate in our society, which appears to be groups of people who support gender critical beliefs, meaning that you can't discriminate against someone like Maya just because she holds gender critical beliefs, and those who advocate for trans rights. And I say that this conflict is an effect of the Equality Act itself, and it reflects certain problems with the way that our legal system, which is an equality system, works or doesn't work. And the problems are that, first of all, the protected characteristics in this debate are not clear at all. We've got a colloquial term, trans, which is a stand-in for the legal term, which is gender reassignment. But we don't really know how trans and gender reassignment fit together, whether they're compatible, whether they mean the same thing or different things. Gender ideology or gender identity, which Maya was arguing against in her case, is not a protected characteristic, whereas the category of sex that Maya was relying on is a protected characteristic. But it looks to us, superficially standing back from the Maya Forstater case, that the conflict is between those who support gender identity, which is not a protected characteristic, versus those who defend sex, which is a protected characteristic. Gender identity has somehow become imported into the protected characteristic of gender reassignment. And I would say that it was imported arbitrarily. And that bodes ill for our legal system, because when you're making law and policy, you don't really know what the arguments or the principles or the definitions are that are informing what you understand to be a protected characteristic. Protected characteristics are just left unclear and arbitrarily defined and arbitrarily relied on. The second problem is there is a distinction in law, and this goes to the Strasbourg jurisprudence, between the right to hold a belief and the right to manifest a belief. And they're not the same. And when Maya took her case at first instance, the judge held that her belief, because she wouldn't use maybe the correct pronouns for a trans person in certain circumstances, she must hold an absolutist belief. And therefore, because her belief conflicted with the rights of transgender persons, it wasn't worthy of respect in a democratic society. I find that together, that point, taken with the point that I made about protected characteristics being unclear, presents a whole host of problems for particularly lawyers who are trying to understand whether a belief is protected or whether it's only the right to manifest a belief in certain circumstances which is protected. In Article 9 of the ECHR, that's the distinction between the right to hold a belief, which is unqualified, versus the right to manifest or express a belief, which is qualified. So the judge needs to decide when and where a belief can be manifest. And of course, before that, the judge has to decide whether the belief itself is protected. If the protected characteristics are not clearly defined, then legal decisions about what is protected and what is not will appear increasingly arbitrary and effectively devoid of legal reasoning. I've already touched on the difference between holding a belief and manifesting a belief. And then, of course, there's manifesting a belief in certain situations. The judge will have to decide in which situations it is acceptable to manifest a belief. This is a protected belief system. And what I say, and this is the nutshell of my argument, is that all of this equality regime based on protected characteristics and protected beliefs in particular is wholly at odds with what I would call a common law jurisprudence, where there is a presumption that people have freedom to express their views. Okay, so we need to understand whether views are protected under the protected belief system, which they are not, I will argue. It is really important to remember that in order for a protected belief to be protected, it has to be argued as a belief, and it has to be argued that that belief be recognised as protected in order for a claimant to for their claim to succeed. So it's not just a question of going in and saying, I hold a protected belief. You have to argue for that belief, and you have to argue for its protected status. And what I would say to you as a way of a thought provocation is, what was the belief that Maya was contesting? What was the belief that Maya Forstater stood against? If her belief was that sex is immutable, that sex is important, and not to be conflated with gender identity, then presumably she was addressing a hidden or secret belief in the room where sex is unimportant, sex is a fiction, and actually sex can be conflated with gender identity. Well, when did the judge decide that that belief was protected? No judge ever did, because there hasn't been a case at law where that belief was tested. So what we have are beliefs like gender critical beliefs, which have to be fought for and argued for and defended, and hopefully a judge will decide in our favour that the belief is protected, against something that I would call an inferred status quo. That is to say, the belief that sex is a fiction. That was just taken as read in Maya Forstater's case, and I submit that there we have a two-tier system of justice where one set of beliefs has to be fought for and achieve recognition as a protected belief, and another set of beliefs are just taken as a priori, inferred as the status quo. This is a hot mess. This is legally incoherent. It doesn't allow for a public understanding of what is being debated as a protected belief and what isn't. This is not how definitions in law work. Even in Maya Forstater's case at appeal, Justice Chowdhury said the fact that the majority of people hold gender critical beliefs should be taken into consideration when we're thinking about whether to protect it. But it wasn't the defining criterion as to why Maya's belief should be respected or recognised. So what we're looking at is a system where even if the whole of the country is totally agreed that there are men and women and you can't change sex, that wouldn't qualify it necessarily as a protected belief. But the corollary of that view is somehow protected. And so this gets at the way in which we have, what is that? Is that 1 minute? So basically what I wanted to do, but I'm out of time, and I think I'll come back to this because it will engage questions, is that there has to be a legal test as to what a protected belief is. If you want to argue that your belief is worthy of respect in a democratic society, you have to follow the test. That is the Granger test, which I can take you through step by step if you're interested. But the main point about beliefs as defined by the Granger test is that they exclude political opinions or opinions and viewpoints of any kind. You have to show that your belief is something other than a view or an opinion, and that means that you are basically subscribing to a system which goes completely against common law presumptions of freedom of expression, and it also goes against the Strasbourg understanding of free expression, which is protected under Articles 9 and 10, and Article 14, because Article 14 of the ECHR, and I'm finishing, actually allows for protection of opinion. And so what we're seeing is the belief system that we see in Forstater actually displacing the common law presumption of a right to a view or an opinion. A belief is something else. It has to be argued for, and the threshold, if we look at the test, which I'm happy to take the audience through, sets an extremely high bar, because a protected belief has to be akin to a religious belief, and a believer has to be equivalent to the adherent of said religion. And that high bar is total anathema to the presumption of freedom under common law. Thank you very much.
Thank you, Anna. And now, to oppose the motion, please welcome to the stage Maya Forstater.
Thank you, and thank you, Anna Loutfi. So Anna presented the case that there should be no protected beliefs, and secondly, that the Equality Act is not fit for purpose. So my job is to persuade you, at a minimum, that the Equality Act is reasonably fit for purpose. That's the test I'm putting myself. Not that it's perfect, not that it can't be tweaked a little bit, it's a long act, but that it's reasonably fit for purpose, and that there should be protection against belief discrimination as part of that. So what I'm going to tell you is 5 things, if I do it in time. Why the Equality Act doesn't give any belief special protection in law, what the purpose of the Act is, what would happen if we didn't have it, how it works, and why the hell belief is in there at all. So first, the Equality Act doesn't give special protection to any belief in law. It's not about special protection. You often hear the Equality Act misnamed as the Equalities Act, and that makes lawyers cry. This betrays the misunderstanding that the equality law works like a point system. Who is the most vulnerable? Who is the most marginalised minority? But it doesn't work like that. It's equality singular. It's a concept that includes everyone. Rather than being an act about special protection for special people, we can think about it as the You're Not So Special Act. At its core, the Equality Act protects everyone. Women don't have special protection. Everyone has protection against sex discrimination, men and women. Black people don't have special protection. Everyone has protection against race discrimination. 65-year-olds don't have special protection. 18-year-olds don't have special protection. Everyone has protection against age discrimination. And the Equality Act provides the framework to ask, in any particular situation that's covered by the Equality Act, which means the economy, education, goods and services, not your home and family, were you treated less favourably directly because you have or are perceived to have or are associated with one of those protected characteristics, and indirectly was a rule applied that disadvantages people who have that protected characteristic, and the rule was not justified. And protected characteristic is used here. It's basically a placeholder in the law, and what it means is age, race, sex, disability, sexual orientation, marriage, so on and so forth. It would be used 119 times in the law if they had to make that list every time. So they came up with this word, protected characteristic, which means the relevant grounds of discrimination in that situation. So what is the purpose of the Equality Act? It's a consolidating act. It brought together over 100 pieces of equality legislation in 2010. So the purpose of it is to restate those acts. That doesn't really answer the question. What is the purpose of those acts? Well, the purpose of the Disability Discrimination Act, passed in 1995, was to make it unlawful to discriminate against disabled people in employment, the supply of goods and services. The purpose of the Sex Discrimination Act, 1975, was to render it unlawful to certain kinds of sex discrimination. Race Discrimination Act, 1965, prohibit discrimination on racial grounds. You can see where I'm going with all of this. So the organisers of this debate asked, in a free society, should employers not be free to discriminate? That's a different question from whether the Equality Act is fit for purpose. You can take a principled libertarian stance that says that employers, private sector employers and service providers should be able to discriminate with impunity based on race, based on religion, disability, age. It's freedom. It's a kind of freedom. That's not a disagreement with that's a disagreement with the purpose of the Equality Act. So let's think about that. What if we didn't have it? Let's go back. If we went back before 1995, disabled people in the UK would face widespread structural routine discrimination in public life, in jobs, in restaurants, in education, in transport, and so on. Or we could go back to the early 1970s. I was born in 1973. At that time, women could be fired from jobs for being pregnant, for getting married. They could be paid less explicitly. They could be confined to particular jobs. I don't want to go back to that. Or we could go back to the early 1960s. My parents came into this country in 1962. My dad is American, my mum is Asian. And they used to turn up, to rent a flat and ring from the phone box on the corner and say, we're coming to visit this flat. 5 minutes later, they'd turn up and they'd look at my mum. They'd look her up and down and they'd say, oh, it's gone. Or they'd say, we don't want the Viet Cong round here. My mum's not Vietnamese, but that's discrimination by association. Or they'd say, yeah, we're not racist, we just don't like the smelly food. That's indirect discrimination. All of those things are now unlawful. It took quite a long time for that message to get through. I don't want to go back to that. We could go back to 1919, the Sex Discrimination Removal Act, which allowed women to sit on juries and be judges and be awarded degrees and have professions. I don't want to go back before that either. So in a free society, should the employers be allowed to discriminate and say, no Jews, no blacks, no Irish, no women getting ideas above their station? I don't think so. So that's the purpose of the Equality Act, and I'll stand up for that. If we didn't have it, we'd have to reinvent it. So how does the Equality Act work? It's about 250 pages. 3 pages of it say, don't discriminate against people because of their protected characteristics. That's what I said. The other 200 odd pages say, apart from in these situations. And the reason why it says apart from these situations is because you are having to balance equality, meritocracy, freedom of association, and protection for the vulnerable. If you treat men and women equally in all situations, you would end up with the Olympics full of men, for example. You have to do things specifically for women, you have to do things specifically for disabled people, specifically for older people, specifically for younger people, for example. So there are lots of don't discriminate apart from where you can. Freedom for the wolves is different from freedom for the lambs. And we're all wolves sometimes, and we're all lambs sometimes. Sometimes we want freedom to do the things we want, and sometimes we want freedom from those who would do things to us. The Equality Act constrains the freedom of employers and private businesses and the state to discriminate in some situations in order to create a society where everyone is free to participate. It's not perfect, but I think it's fit for purpose. So why is belief in there? It does seem like an odd one out. Some people say, well, sex, race, disability, these are real things. You can't choose them. They're definable in some of them are more definable than others. But what about belief? One answer is belief is pretty much indivisible from race in lots of situations. It's not really about what you believe. It's about you're not from round here, you're not part of this tribe, you're from somewhere else. So if you're going to protect people against race discrimination, you also want to protect against religious belief discrimination. And then if you go back, I went back to 1919 with our equality laws. If you go back further, the very first anti-discrimination laws were anti-belief discrimination laws. So 1846, which the Religious Disabilities Act, which extended rights and freedoms on education, property and the administration of charities to Jews in this country. The Catholic Emancipation Act 1829 allowed Catholics to sit in Parliament, to hold offices and to vote. The Papist Act 1778 allowed Catholics to join the army and to purchase land if they pledged an oath of allegiance. Religious discrimination is one of the oldest forms of discrimination that we have legislated against. Belief is just one of those things that people get discriminated against for, and the Equality Act's purpose is to protect people against the kinds of things that people get unfairly discriminated against for. And so if you accept the idea that we should protect people against discrimination for being Jewish, for being Catholic, for being Muslim, you also should protect people against discrimination for not being those things, for being atheist, for being an ex-Muslim, for being an agnostic. Is that
1 minute?
1 minute, okay. So you have to protect people against religious belief, lack of religious belief, but also non-religious belief. What about being a Buddhist, a Stoic? What about being gender critical? One-sided discrimination law is special protection for some people. Broad-based discrimination law protects everyone against discrimination. And so I would say, in reply to Anna Loutfi, the bar of a belief being worthy of respect in a democratic society and meeting the tests to be a protected philosophical belief are low, and that's the way they should be. Basically, if you're not a Nazi and your belief is basically coherent and you are discriminated against because of it, you have protection.
Similarly, if you think that Trump is a legitimate leader of the free world, that is not a protected belief. If you ground what you think based on what you understand to have been Trump's legitimate election campaign and the legitimacy of the funding. In short, a protected belief is something that cannot rely on scientific knowledge or any kind of information that is available at the present time. It has to be something that is outside of knowledge. It has to be something that is somehow has this mystical status of protected belief, because it's like a religion, but it's not a religion. And that is a high bar. And I say that we had a very good system before, yeah, I'm finishing. We had a very good system before the Equality Act, which was a presumption that we could freely exchange ideas and opinions based on information or otherwise. Thank you.
And Maya to respond.
So the case law that defines what a protected belief is a case called Granger and Nicholson. Mr. Nicholson's belief was in climate change. So it's a scientific belief. He believed climate change is important and urgent and we must act on it. And that's the bit that was, when I was working out how to articulate my belief, I thought my belief that sex is real and mutable is a scientific belief. You know, if a third gamete turns up, I'll change my view, but it hasn't. But the other part of the belief was, like Mr. Nicholson, it's important. That's the bit that makes it a worldview, makes it something like a religion. Before the Equality Act, as I said, we had 100 different anti-discrimination laws. We already had religion or belief discrimination, I think, since 1993. So it's not something that came in new with the Equality Act. And it protects against discrimination on the basis of belief or lack of belief. So it really doesn't create special beliefs. It doesn't put them on a pedestal. It doesn't give people rights if they have a particular belief. It just says, if you're unfairly denied a venue, denied service by a company, denied a job, and I now run a gender critical organisation, Sex Matters, and we're denied this stuff all the time. And we ring up and we want to book a venue, and they say no. We try and join things, and they say no. And people are being discriminated against all over the country in jobs for saying they don't want men in women's changing rooms. The belief does not have to be fancy. And it can be belief or lack of belief in gender ideology. That was the other way that I claimed it. So it really isn't a high bar. And it protects people against bigotry and discrimination, which is a different thing from protecting freedom of speech. Freedom of speech is great, but people still need to pay their mortgages. And for that, they need belief discrimination.
Just quickly try and set this here. 2 minutes again. So this way. Yeah.
Oh, okay.
We'll go back and forth in 2 minutes. We can go back and forth in 2 minute sections for a little bit.
Look, we're inculcating a culture of dishonesty here. It's not the case that people have protected beliefs and then get themselves into a mess at work. What happens is they get themselves into a mess of work because they've tried to share a view or an opinion, and then they have to, after the fact, invent a belief system that meets the test. So this is actually a dishonest system, because people don't go around actually saying that they're gender critical. That was invented for the purposes of Maya's case. Yes, it has its use value, but I don't want to live in a world where I have to classify myself as gender critical and then argue that that is my worldview and my important, a substantial part of how I live my life, in order to be able to say that I don't want that guy in my changing room. Okay, so that's the basic thing. If I could just tell you something about the beliefs that have been protected versus those that haven't in law, then perhaps you can see my point without me having to waffle on. It is protected, for example, to be an ethical vegan, but only if you're an extreme one. Anti-fox hunting is protected. Scottish independence. Public services as a common good is a protected belief. Lying is always wrong is a protected belief. Democratic socialism is a protected belief. Trotskyism isn't a protected belief. Participatory democracy is a protected belief. And the fact that mediums can be in communication with the dead is a protected belief. Anti-Zionism is a protected belief. But Jews are God's chosen people is not a protected belief. BNP membership is not a protected belief. Poppies to be worn in November is not a protected belief. 9/11 was a false flag, not a protected belief. Homosexuality is against God's law, not protected. Holocaust denial, not protected. Vegetarianism, not protected. Not protected because it's a lifestyle choice. Thank you. Homosexuality is against God's law.
Protected.
Oh, it has in the Gobi, but in another
Yes.
case, yeah, that's the other thing. In some cases, the same belief is protected, and in another case, that same belief will not be protected. It's incoherent.
Or is it?
I go again? Oh, okay. Anna said a couple of rounds ago that a problem with belief is that it can't be defined. Protected beliefs can't be defined. Either can race. We don't require people to register their race or to be of one race or another race or have any number. We don't define the number of races, but people can show that they have been discriminated against because of race. It's different from sex. There are two sexes, we know what they are. So this point about whether the thing can be defined neatly is a different question from whether people suffer unfair discrimination because of it. And it's fine to want to have the freedom to say, that's a man, I don't want him in my changing room. But if you also want to not get fired for that, you need to have protection. And the idea that the employers should have the freedom to discriminate against people is the freedom to fire you for saying something that they disagree with. So, I mean, it's a question. How much freedom do you want versus how much protection do you want? Anna went through a bunch of different things that are and aren't protected beliefs. There are 5 tests. I'm not going to go through all of them, but the one that I originally failed on and then won on was this: is it worthy of respect in a democratic society? And that's the question of whether the belief fundamentally destroys or undermines other people's fundamental rights. And so that's why a belief in a Trotskyist revolution, for example, is not a protected belief. If you want to overthrow the government by violent means, I think is the one, that's not a protected belief. If you think, I can't remember what the exact ones about Jews being the chosen people, but if you don't respect other people's rights in a pluralistic country, then your belief cannot be protected. And it's true that the belief in gender identity has not yet been tested, and I don't think it's necessarily clear that that belief is worthy of respect in a democratic society, because it does destroy other people's human rights.
I'm glad you drew attention to that point at the end, because that was going to be the subject of my 2 minutes now, which is it hadn't been dealt with to date until Maya raised it just now. How do we account for the fact that what Maya was arguing against appears to have protection without anyone ever having to sort of make that argument? And the reason that it has protection is because of the Equality Act, because the Equality Act provided us with something that's incoherent, which is the idea that you can change sex if you have gender reassignment. But no one really knew what sex meant in that context, nor assignment. And of course, there's been all sorts of overlaying of interpretations. Many of those overlays have taken place outside of courts and tribunals. They've been cultural narratives that have been driven through social media and in the public square and through political activism. But they don't necessarily reflect any legal determination that was taken by a judge in a court or tribunal or in an Act of Parliament. The Act of Parliament just tells us that there's something called gender reassignment, but all the subsequent overlay of interpretation, which is that means a man can just declare himself a woman and that somehow is protected under the Equality Act, that was a cultural intervention. And yet we treat that as somehow the status quo against which Maya had to bring her challenge. Well, that's a 2-tier system, and I say that those two-tier elements operate in every belief area and also in other areas of protected characteristics as well. Yes, in theory, men are protected under the Equality Act because they have sex, and white people or white Britons are protected under the Equality Act because they have a race. But we know that where there are cultural narratives that decide a priori that some protected characteristics are more vulnerable, some protected characteristics are, have historically suffered systemic discrimination, and the job of the state and the job of the employer is to somehow compensate for that failure in the past, that we do see a 2-tier system and we do see pitting of groups against each other. And the judge will be confronted with the unenviable task of deciding in every circumstance which group is more vulnerable and why. And this is all unnecessary. I'm actually trying to cut to the quick and say, we don't need it. We have a presumption of freedom. If you don't like what someone says, that's of course, there will be circumstances where that might be relevant in an employment context, although I would suggest it's a subject for mediation between adults in a room, rather than, you know, years and years and years of litigation that is expensive and actually just ends up confusing the public even more. If you ask the average Joe on the street what is a protected characteristic, they won't tell you, because they don't know. And if you ask the average Joe on the street what a protected belief is, they won't be able to tell you, and they certainly won't be able to tell you why ethical veganism is protected but vegetarianism is not. And I'm an employment barrister, and I can't tell you. And I think that we have to take seriously, very seriously, the fact that if a system is lending itself to more and more fraught relationships in society and more incoherence in terms of what the law actually means, look at the Supreme Court judgment. Even after it was held at the Supreme Court that sex means sex, right? It was still decided at the national level that no one knew what that meant. And that is the problem, ladies and gentlemen. And I beg the motion. Thank you.
No one on the street knows why Jaffa cakes are cakes. But the hope that there are long legal reasons, and for VAT reasons, Jaffa cakes are cakes. Don't ask me why. We don't need to know the law. That's what we have lawyers for. But the ability to go to court, to plead your case, to have a judge decide, to get justice, is the foundation of a democratic society. And if we leave it up to cultural narratives, they get it wrong. I would much prefer to be able to go to court and to have my rights and to have my day in court, which I did. Took 4 years for me personally on my job, the protected characteristic of belief. I got compensation. I created a precedent. That precedent protects other people at work. The organisation I founded, Sex Matters, went to the Supreme Court with former in Scotland, and we got clarity on what the meaning of the protective characteristic of sex is. We didn't leave it up to the cultural narratives to decide. And I think, you know, Anna says, if you don't like what someone says, then that's between adults. You can do what you want. The law shouldn't say anything. But that would also, you know, if we get rid of the Equality Act, that also applies if you don't like someone's race, if you don't like the way their cooking smells, if, you know, all of those things where we are protected against discrimination because employers are not able to do exactly what they want and not able to play out their own prejudices in the workplace, in university, in schools, in public services. I think that's a hugely important protection that we have, and that it's too valuable and important to squander.
Say more.
Yeah, I think take a break. Yeah.
Right. So, guys, we'll take a 10-minute break. The time is. Can someone tell me quickly? I'll ask 3 people for a question, 1 minute each, and then we'll give each speaker 2 minutes to reply. In your question, you can state whether you're particularly. You can bark. Yes. Well. You can state whether you're particularly for either side or not, but please try and keep it as a question, and please try and keep it to 1 minute, and I'll be gaveling you guys this time. So, can I get a show of hands for as a question? I'll ask 3 people to ask them. So we'll go you there, Miss, yourself in the black, and then Alex. We'll go for. Yeah. So first yourself.
I'll stand up and I've got a cold. I'll try to get the voice very well. This might be a can of worms. Sorry. Is the government's new definition of Muslim hatred or Islamophobia, or whatever it was, is it in line with the Equality Act, or is it in tension with it? If it's in line with it, then why was it needed, and what's all the fuss? If there is a tension, then which one takes priority in law, the act or the definition?
Thank you. And yourself in the black. Yeah. We'll do 3. We'll do 3 questions each. 3 questions for the audience, okay. and then.
Okay. And I really love your speeches, and I completely agree that you shouldn't have to live in a world where you make up this whole philosophy just to justify your basic freedoms. But I wanted you, if you could, just address my concern on enforcement and what regular people could do in the absence of these protections in the equality law to actually protect themselves against discrimination by their employers, let's say, and whether you believe people will know about this legal recourse and whether you think it will be effective in this two-tier system that we've created.
And Alex.
Thank you very much. A very important debate being had, and I can't help thinking of that line from George Orwell's 19, or Animal Farm even. Some are more equal than others, because of course the law is arbitrary, and what we are assuming perhaps, or not necessarily all of us, but is that judges themselves are not prejudicial, that they're not political appointees, they're not following a particular cultural or political narrative.
Speak up a little,
The law.
people at the back.
Yes, sorry. So I'm just saying that what we're assuming is that judges themselves may not be themselves political, according to the narrative, because they're political appointees in effect, de facto, and that has caused a lot of the arbitrariness that you mentioned. I would like to see, this is my question really, and it's not so much a question, but I'm just stating what I'd like you to explore a little bit more. First of all, section 159 of the Equality Act, which is on affirmative action, and a lot of the problems that's caused because it's been interpreted arbitrarily, and the judge has been arbiter of, who is oppressed, who is historically oppressed, and also, and I appreciate this is not the Equality Act, but also hate crime, and what's the consequences of the belief system, because I believe that belief systems are themselves inherently discriminatory, and that in itself causes a problem, or can be discriminatory, because that causes conflict between different belief systems.
Thank you, guys. So we'll go for Anna first for 2 minutes to respond to any or all of those, and then to Maya for 2 minutes.
Well, look, it's really stressful having to do this in 2 minutes. I mean, they're not easy questions, and this isn't an easy legal area. Let me try to deal with things together. The definition, the non-statutory definition of anti-Muslim hostility is non-statutory. So the question that was raised is quite a valid one, which is, what is its relationship with the Equality Act? The answer is nothing, because the Equality Act protects Muslims from discrimination. So why do you need a non-statutory definition of anti-Muslim hostility if it's already, there's a threshold whereby you can't discriminate against persons who are Muslim by virtue of the fact that they're Muslim? This means that the Equality Act, much as we may loathe it or love it, is becoming actually something that's receding on the landscape of law, to be replaced by non-statutory definitions, which are basically government edicts, and those non-statutory definitions will be greedily absorbed by stakeholders in the public sector particularly, and guidance will be issued as to how to implement these non-statutory definitions and to regulate people's lives. And actually the Equality Act will become something of a irrelevance, because what matters is the cultural narrative, which is we mustn't be unkind to Muslims, and no one knows what a Muslim is, and no one knows what being unkind is. It's arbitrary. For example, if a Sunni Muslim decides to treat a Shia Muslim in a certain way, does that meet the definition of anti-Muslim hostility? I have a case next week where that question is going to be put before a judge. When you talk about section 159, which is positive action, that is a statutory provision under the Equality Act, sections 158, 159, where if it's held that a certain group has suffered in some ways difficulties in terms of, let's say, access to resources, an employer or a public body can actually enact a corrective measure whereby a particular group that is seen to be vulnerable or deprived of resources can be given resources over and above another group. That is to say, positive action is a version of what the Americans call affirmative action or positive discrimination. And those provisions are, they are not really legally set out in terms of how do you decide whether a group is entitled to that kind of discrimination. This is going to be an arbitrary decision, and it will be driven by cultural narratives about whether a group is somehow systemically oppressed compared with another group. Yeah. So that would result in a situation where, for example, if someone decides to argue that black people are, have systemically suffered disadvantage, then this category of black will be treated as if it has been already defined in law as something that has historically been disadvantaged, even if black were to contain, membership. Of, let's say, well-educated Asian doctors would be in the same class of black as some other Jamaican working class, never been to university category. And so these are arbitrary, and they are driven by cultural narratives which say that people with melanin in their skin are somehow historically, prejudiced against. And I just want to, may I just say something on enforcement? Yeah. I was given 3 questions. Okay. Listen, do the maths. You've got 3 questions and 2 minutes, and they're legally technical points. Some are more equal than others, was the point I just addressed. But the question that you raised was on enforcement, which is how do we protect people against discrimination? As in Maya Forstater's case, she needed the Equality Act in order to argue her case. But I would say that if it hadn't been for the Equality Act, there would have been no perception that she had actually breached any law, because the Equality Act was the reason that she was held to be a transphobe. Had there been no Equality Act, she would have kept her job. Thank you.
Not true. Not true. My employer didn't know shit about the Equality Act. They were Americans. And they had their own cultural narrative. It was an American organisation. I was working for the UK branch of it, and they weren't doing it because of the Equality Act. They were doing it because of their own cultural narrative, and the Equality Act protected me. Judges in this country are not political appointees, but they are trained, and they have been trained in a wrong interpretation of the Equality Act for 15 years. They were trained to think that we had gender self-ID and that it was kind of parallel to the Islamophobia definition, hatred and transphobia, not to recognise somebody's gender identity. The Equality Act doesn't say that. The guidance to judges did. And we've used the law to drive that guidance out. And I hope that people will be able to use the law to challenge the non-statutory definition of Islamophobia, because we don't have heresy laws in this country. I'm not a big fan of Section 159 of the Equality Act, but the point is, this is the positive action bit in employment. It's one of those bits in the 200, apart from where, don't discriminate against people based on protected characteristics, apart from where you can. And there are, 159 is quite low down the list. There are 100 different places where you can, roughly. The reason why people don't like Section 159 is because it allows people to use race, religion, sexual orientation as reasons to employ somebody, whereas the core of the Equality Act says don't do that. We mustn't throw the baby out with the bathwater. The core is the don't do that. Then the question of whether Section 159 works exactly how it should is a different question. This is why I say the core is fit for purpose. We might want to amend some of the ways some bits of it work. It's not affirmative action like they have in the US. It's quite limited what you can do, but I don't think it works great. I think people should understand and use the law. It's one of the few tools that we have. We shouldn't fall into despondency and fatalism, and it's the cultural narrative, which is, it's just much harder to shift cultural narratives than it is to fight your case in court. It's hard to fight your case in court. It costs money, but it's not impossible. And when people do it, it helps everyone else to understand and use the law better. So the law is there for us.